investment opportunities for the country.
And the other ministerial statement was rendered by the Minister of Home Affairs and Internal Security on the issuance of national registration cards through mobile registration.
The other ministerial statement was also from Mr. Honorable Mlambo Haimbe, State Council MP, and it was on the official working visit to Japan, 3rd to 5th February 2025. Let's quickly look at what is yet to be considered on the floor of the House. Shortly, you have the chairperson of the Committee of the whole House conducting business. And remember, the Cyber Security Bill, National Assembly Bill number 29, 2024, and the Cyber Security Bill, National Assembly Bill 30, 2024. And these bills were consolidated, so the House is still in committee, and shortly after business resumes, the House will continue considering this bill. Do you have another bill that is yet to come, Joe?
Yes, Center. So the other bill that is expected to be considered on the floor of the House is the Cyber Crimes Bill, National Assembly Bill number 8 of 2024 at a committee stage, and also the Geological and Minerals Development Bill, National Assembly Bill number 33 of 2024. This will be considered at a third reading stage.
One question for oral answer under Standing Order 82 was considered. It came from Mr. Simpondo Chembe. Cross over to the floor of the House now. The bells are ringing, which means that we do not have a quorum in the House. It is a requirement that 1/3 of the total number of members of Parliament be present in the House for any business to be transacted on the floor of the House. Do you remember that? The House has resolved into committee to consider the Cyber Security Bill, National Assembly Bill number 29 of 2024, and later on we expect the House to consider the Cyber Crimes Bill, National Assembly Bill number 30 of 2024, and the Geological and Minerals Development Bill, National Assembly Bill number 33 of 2024, which is expected to come at third reading. Let's quickly look at question 275, Joe, which came from Mr. Simpondo Chembe, Member of Parliament.
Yes, indeed, Center. So Mr. Clifford Mpundu Chembe, Member of Parliament, did ask the Minister of Energy, wanted to find out why health facilities in Chembe Parliamentary constituency are subjected to load shedding by ZESCO Limited, despite the presidential directive not to load shed health facilities. And I also wanted to find out what urgent measures are being taken to ensure that the health facilities are not load shedded in order to prevent loss of life.
All right, so the other question, that's question 276, which was supposed to come from Mr. Mtachalo, Chairman of Member of Parliament, lapse, and we expect the House to consider the Cyber Crimes Bill and the Geological Minerals Development Bill. Currently, the House is considering the Cyber Security Bill, National Assembly Bill number 29, 2024 at committee stage, and at the time business was suspended for the lunch break. It was Kamfinsa Member of Parliament, Mr. Christopher Kangombe, who was on the floor of the House debating some of the amendments that have been proposed to be considered in this bill.
Yes, indeed. So yesterday the acting leader of government business did move a motion that Standing Orders 27 and 123 be suspended to enable the House to complete all business on the order paper, and all matters arising therefrom are also to consider more than one stage of a bill on Friday, which is today, 28th March 2025, and on such completion the House adjourns sine die. So this is arising from the motion which was moved yesterday.
I'd like to welcome your viewers on our social media platforms, be it on YouTube, indeed not forgetting on Facebook. I'd like to say thank you so much, and let us know where you're watching us from. Once business is concluded on today's order paper, the House is expected to adjourn sine die. So let's be together For now, we'll leave you with live visuals, and once the quorum is constituted, business resumes. So Joe and I will be on hand to give you live commentaries. Do remember that we still have the two sign language interpreters, Joe, that's Jason Manda and Chola Kauma.
I'm part of the house. Unless if one is on the... Unless when I'm on that seat.
Quorum is 160, is 1/3 of 167.
Business was suspended. The House was considering the committee stage of the Cyber Security Bill, National Assembly Bill number 29 of 2024, and Mr. Kangombe was making his submission on the amendment of Clause 30. May Mr. Kangombe continue and wind up his submission. Let's not repeat what was discussed at second reading, because a lot of discussions were done.
Madam Chairperson, you've guided that I should not repeat what I already indicated. The summary, Madam Chairperson, of my submission this afternoon in relation to Clause 30 is that we should delete it. That is the amendment that I'm proposing, for the simple reason that the concerns around interception orders, Madam Chairperson, are already covered under Clause 29. I beg to move.
Thank you. Mr. Mpundu, please let's avoid discussing what has been mentioned or discussed before.
Thank you, Madam Chairperson. Very quickly, in support of the amendment moved by Mr. Kangombe, you can see clearly, Madam Chairperson, the confusion being created by these two propositions. In 29, the minister is proposing to alter the existing law by removing that layer of authority. Again, in 30, there is now proposing something completely different. In 29, you are saying it's too ambiguous, or it's too much of a procedure to go to the Attorney General and to also go to the judge. Again, you change and you propose that an officer can simply make a phone call to a service provider for them to be able to access our private conversation. You can see that what Honorable Mr. Kangombe is making is basically, why do we want to then create these two arrangements that conflict each other? So, through you, Chairperson, our appeal through on Mr. Kangombe is that there's no need for having, Clause 30. It must be deleted because it conflicts 29. 29 is enough. It guarantees, at least because the minister has insisted, let's have just a one-layer approval process. It's enough. We can accept that. Okay, we'll have a one-layer approval process, but to insist that an officer can just make a phone call to a service provider and intercept our private conversation is extremely absurd, Madam Speaker. So I want to be on record to support the amendment being moved by Mr. Kangombe, and I think on this score, through you, Chairperson, the minister must just give in, because we are not asking for too much. All we are asking is that at least if you are going to invade in our privacy, at least go and get a consent from the judge. You cannot leave it to the law enforcement officers to continue prying on our privacy by simply making a phone call to the service provider. So I just wanted to be on record. I think that, Minister, we are not asking for too much. You have already done so much damage. Here, we want you to give in. I thank you, Chairperson.
I think it's clear. The Honorable Minister of Technology and Science.
Thank you, Madam Chairperson. We dealt with Section 29, and now we are dealing with Section 30. And there's a distinction between the two sections, and let me explain. Section 30 specifically deals with emergency situation. 29 deals with ordinary day-to-day situations. Section 30, Madam Chairperson, also defines the circumstances when you can actually invoke it. And it basically says, if there is an imminent danger to human life or damage to property, imminent danger, it then requires the law enforcement officer to obtain an oral or make an oral request to the electronic service provider. And the purpose is to avert the imminent danger, which is different from Section 29. And after that is done, Madam Chairperson, there is a requirement to provide an affidavit to the judge giving the circumstances and details for the actions taken. The judgment whether that action taken was proper or not is up to the judge. If the judge determines that it was improper, there are punitive measures. So the reason we have Section 30 is very specific to deal with an emergency, to protect life, and also to save property. That is the basic difference. So it's not even an issue of layers between AG and the judge. It's to be able to take immediate and prompt action.
Thank you.
By the provider. Madam Chairperson, I hope it clears the understanding. Thank you.
Thank you. Mr. Mwambazi?
Thank you, Madam Chairperson. And Madam Chairperson, I thought I would just add a few words because I think the context of Section 29 and 30 are in tandem and they cannot be read in isolation. That's why you start with 29 and go to 30. And we shouldn't look at the words in literal meaning, but the context in which they are aligned. And also there's a proviso, because the amendments being proposed by Honorable Kangombe, if we look at 30, 30 still needs to stand. It's got certain provisions, like the Minister said also, in terms of in an emergency. And these provisos in Section 34, which is A, B, and C, D, provides and also protects abuse, because there are issues of affidavit. Also, the service provider also needs to submit how this recording was done according to the law. So the law cannot be read in isolation to say this one should come out. This 30 comes to critically ensure that in an emergency, when an officer does request for a recording, because you cannot wait and go to 29. This one now goes to the nitty-gritties in an emergency and ensures that such an officer does not abuse, like it said. So, Madam Chairperson, I think in my own understanding and legally, 30 should still stand because it has provided for what some of our colleagues are fearing. I thank you, Madam Chairperson.
Thank you. Do you want to comment, Honorable Minister, or you've already commented?
I've already commented, Madam Chairperson. I think it's quite clear.
Yes.
Thank you.
Mr. Kampyongo, brief.
Very brief, Madam Speaker. Madam Speaker, I think what is key here is to take all the interests into account, Honorable Minister. I know that you have the anti-terrorism law as well, which deals with specific. In that law, you find specific circumstances and how officers should react in those specific circumstances. it comes to the question of who determines an emergency. How is this emergency described? Because if an officer is reaching out to the service provider would not be privy to the emergency. And that's where the gap becomes interesting. We want to know, Honorable Tati is about to do this, and it's an emergency. Who checks that emergency and determine it to be suitable? That's why we don't give blanket provisions even for the enforcers, because the potential to abuse depends so much on the parameters. How do you determine the parameters? What sort of, and like I'm saying, there are so many pieces of legislation that provide for various security circumstances. And I've pointed out one Anti-Terrorism Act, which also has and provides for what circumstances demands for what officers can do in terms of reaction. And that's why the other day, Honorable Minister, I was asking, what enforcement mechanisms are you going to have in your ministry? The only reason why we had this law together,
You can
both,
wind up.
Madam Speaker, was because in home affairs, there are mechanisms to use in terms of enforcing. So it would be important for the minister to speak to who determines what and how this is checked before it is invoked. Thank you.
The Honorable Minister of Technology and Science.
Very briefly, Madam Chairperson, and the reason we have an affidavit is for now the judge to determine whether the circumstances actually qualify in law, and that is the only way you can determine. The judge will determine. I submit, Madam Chairperson.
Thank you. The last member, Mr. Kangombe, try to be brief.
Madam Chairperson, I'm well guided that I should be brief. I think I have taken quite a lot of time to elaborate the requirement that we remain with clause 29 and we delete clause 30. And I'm reading the provision under clause 30, Madam Chairperson. There are two words that have been used. Reasonable grounds, meaning the law enforcement officer now will be required to make judgment. It is clearly up to the law enforcement officer to decide whether here there is harm that might be caused, and that is where, Madam Chairperson, my point still remains. If we are relying on the judgment of the law enforcement officer, we may as well utilize clause 29. That is the submission from the people of Kanfinsa, and I thank you.
Thank you. The Honorable Minister of Technology and Science.
Madam Chairperson, short of belaboring the point, we have already distinguished the circumstances in section 29, which are ordinary day-to-day. And 30 deals with emergencies, and those are defined, the circumstances are defined in law. So you need prompt action. So that is required. And as I said to Honorable Kampiongo, the affidavit is a safeguard. I thank you.
We make a decision on Mr. Kangombe's amendment. The question is that, I put the question. The question is that clause 30 as further amended stands part of the bill. As many as are of that opinion say aye. Of the contrary say no. The noes have it. The question is negative. Amendment falls away. Clause 31, prohibition of use, acquisition, etc. of geolocation and interception information. Any debate and objection, clause 31 is agreed to. Clause 32, interception of communication for purposes of determining location. Any debate and objection? The question is that clause 32 stands part of the bill. The Honorable Minister of Technology and Science.
Madam Chairperson, I beg to move that clause 32 be amended with the words as circulated.
The question is that clause 32 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 32 as amended. Any further debate? I put the question. The question is that clause 32 as amended stands part of the bill. As many as are of that opinion say aye. You don't want to answer. Please support your minister. Support. Okay. I'll put the question again. I put the question. The question is that clause 32 as amended stands part of the bill. As many as are of that opinion say aye. All the contrary say no. I think the ayes have it. The question is resolved in the affirmative. Clause 32 as amended is ordered to stand part of the bill. Clause 33, technical assistance for purposes of determining location or illegal use of spectrum. Any debate and objection? Clause 33 is agreed to. Clause 34, prohibition of access and use of intercepted communication. Any debate and objection? Clause 34 is agreed to. Clause 35, disclosure of intercepted communication by law enforcement officer. Any debate and objection? Clause 35 is agreed to. Clause 36, privileged communication to retain privileged character. Any debate and objection? Clause 36 is agreed to. Clause 37, monitoring. Any debate and objection? Clause 37 is agreed to. Clause 38, interception of satellite transmission. Any debate and objection? Clause 38 is agreed to. Clause 39, assistance by electronic communication service provider. Any debate and objection? Clause 39 is agreed to. Clause 40, interception capability of electronic communications service provider. Any debate and objection? The question is that clause 4 stands part of the bill. The Honorable Minister of Technology and Science.
Madam Chairperson, I beg to move that clause 40 be amended with the words as circulated.
The question is that clause 40 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 40 as amended. Any further debate? I put the question. The question is that clause 40 as amended stands part of the bill. As many as are of that opinion say aye. All the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 40 as amended is ordered to stand part of the bill. Clause 41, cyber security services. Any debate and objection? Clause 41 is agreed to. Clause 42, prohibition of providing cyber security service without license. Any debate and objection? Clause 42 is agreed to. Clause 43, categories of licenses. Any debate and objection? Clause 43 is agreed to. Clause 44, application for license. Any debate and objection? Clause 44 is agreed to. Clause 45, grant of license. Any debate and objection? Clause 45 is agreed to. Clause 46, rejection of application. Any debate and objection? Clause 46 is agreed to. Clause 47, variation of license. Any debate and objection? Clause 47 is agreed to. Clause 48, surrender of license. Any debate and objection? Clause 48 is agreed to. Clause 49, transfer of license. Any debate and objection? Clause 49 is agreed to. Clause 50, renewal of license. Any debate and objection? Clause 50 is agreed to. Clause 51, cancellation or suspension of license. Any debate and objection, Clause 51 is agreed to. Clause 52, register of cyber security service providers. Any debate and objection, Clause 52 is agreed to. Clause 53, identifying areas of cooperation. Any debate and objection, Clause 53 is agreed to. Clause 54, entering into agreement. Any debate and objection, Clause 54 is agreed to. Clause 55, appointment of cyber security inspector. Any debate and objection, Clause 55 is agreed to. Clause 56, power to access, search and seizure. Any debate and objection, Clause 56 is agreed to. Clause 57, appointment of cyber security technical expert. Any debate and objection, Clause 57 is agreed to. Clause 58, appeals. Any debate and objection, Clause 58 is agreed to. Clause 59, search and seizure by law enforcement officer. Any debate and objection, Clause 59 is agreed to. Clause 60, restoration of property. Any debate and objection? The question is that Clause 60 stands part of the bill. The Honorable Minister of Technology and Science.
Madam Chairperson, I beg to move that Clause 60 be amended with the words as circulated.
The question is that Clause 60 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 60 as amended. Any further debate? I put the question. The question is that Clause 60 as amended stands part of the bill. As many as are of that opinion say aye. Of the contrary, the ayes have it. The question is resolved in the affirmative. Clause 60 as amended of the bill. Clause 61, assistance. Any debate and objection? The question is that Clause 61 stands part of the bill. The Honorable Minister of Technology and Science.
Madam Chairperson, I beg to move that Clause 61 be amended with the words as circulated.
The question is that Clause 61 be amended with words as circulated. Any debate and objection? Amendment is to Clause 61. Any further debate? I put the question. The question is one as part of the bill. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 61 as amended is to stand part of the bill. Clause 62, evidence obtained by unlawful interception not admissible in criminal proceedings. Any debate and objection? Clause 62 is agreed to. Clause 63, prohibition of obstruction of law enforcement officer. Any debate and objection? Clause 63 is agreed to. Clause 64, offenses relating to critical information or critical information infrastructure. Any debate and objection? The question is that Clause 4 stands part of the bill. The Honorable Minister of Technology and Science.
Madam Chairperson, that Clause 64 words as circulated.
The question is that Clause 64 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 64 as amended. Any further debate? I put the question. The question is that Clause 64 is part of the bill. As many of that opinion say aye. Of the contrary say no. The ayes have it. The question is resolved. Clause is ordered to stand part of the bill. Clause 65, submission of information by contract. Any debate and objection? Clause 65 is agreed to. Clause 66, general penalty. Any debate and objection, clause 66 is agreed to. Clause 67, power of court to order cancellation of license, forfeiture, etc. Any debate and objection, clause 67 is agreed to. Clause and objection, clause 68 is agreed to. Clause 69, standards. Any debate and objection, clause 69 is agreed to. Clause 70, exemptions. Any debate and objection, clause 70 is agreed to. Clause 71, compounding of certain offenses by agency. Any debate and objection, clause 71 is agreed to. Clause 72, administrative penalty. Any debate and objection, clause 72 is agreed to. Clause 73, regulations. Any debate and objection, clause 73 is agreed to. Clause 74, repeal of Act number 2 of 2021. Any debate and objection, clause 74 is agreed to. General amendment. Any debate and objection? The question is that general amendment stands part of the bill. The Honorable Minister of Technology and Science.
Madam Chairperson, I beg to move that the bill be amended on pages 44 to 46 with the words as circulated.
The question is that the bill be amended on pages 44 to 46 with words as circulated. Any debate, any objection? Amendment is agreed to. The bill as amended on page 44 to 46, any further debate? I put the question. The question is that the bill as amended on pages 44 to 46 stands part of the bill. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. The bill as amended on pages 44 to 46 is ordered to stand part of the bill. Essential of schedule after page 46. Any debate and objection? The question is that the bill be amended after page 46. The Honorable Minister of Technology and Science.
Madam Chairperson, I beg to move that the bill be amended after page 46 with the words as circulated.
The question is that the bill be amended after page 46 with the words as circulated. Any debate and objection? Amendment is agreed to. The bill as amended after page 46. Any further debate? I put the question. The question is that the amendment after page 6 stands part of the bill. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Long title. Any debated objection? Long title is agreed to. The bill will be reported to the House as having passed through the committee with amendments. Where is the bill? That's the next one. Oh. We move to the next bill. The Cyber Crimes Bill, National Assembly Bill number 30 of 2024. Clause 1, short title. Any debate and objection? Clause 1 is agreed to. Clause 2, interpretation. Any debate and objection? The question is that Clause 2 stands part of the bill. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that clause 2 be amended with words as circulated.
The question is that clause 2 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 2 as amended. Any further debate? I put the question. The question is that clause 2 as amended stands part of the bill. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 2 as amended is ordered to stand part of the bill. Clause 3, prohibition of unauthorized access to computer system and data. Any debate and objection? Clause 3 is agreed to. Clause 4, prohibition of unauthorized interference with computer system and data. Any debate and objection? Clause 4 is agreed to. Clause 5, prohibition of unauthorized disclosure of data relating to critical information or critical information in infrastructure. Any debate and objection? Clause 5 is agreed to. Clause 6, prohibition of unauthorized possession of data relating to critical information or critical information infrastructure. Any debate and objection? Clause 6 is agreed to. Clause 7, illegal acquisition of data. Any debate and objection? Clause 7 is agreed to. Clause 8, prohibition of introduction of malicious software into computer system. Any debate and objection? Clause 8 is agreed to. Clause 9, prohibition of illegal system interference. Any debate and objection? Clause 9 is agreed to. Clause 10, prohibition of recording of private conversation without prior notice. Any debate and objection? The question is that clause 10 stands part of the bill. Mr. Kangombe, we have an amendment by Mr. Kangombe.
Thank you very much. Madam Chairperson, one of our responsibilities as members of Parliament is to make laws. And today, Madam Chairperson, we are performing that responsibility. Clause 10, Madam Chairperson, of the bill. It reads, and I quote.
You haven't followed the procedure. The question is that clause 10 stands part of the bill. Mr. Kangombe?
I beg to move that clause 10 be amended with words as circulated.
The question is that clause 10 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 10 as amended. Any further debate? Mr. Kangombe.
Thank you very much, Madam Chairperson. Clause 10, Madam Chairperson, of the bill, it reads, and I quote, a person commits an offense if that person using a device records a private conversation without notifying the parties to the conversation. Madam Chairperson, the proposed amendment is that we should insert the word intentionally immediately after the word device, meaning a person commits an offense if that person using a device intentionally records. That is the proposed amendment to the clause, and as a result of including that word intentionally, Madam Chairperson, it means that we have to delete subclause 3. Now, what is subclause 3 saying, Madam Chairperson? Under subclause 3, Madam Chairperson, a law enforcement officer is being exempted from this offense. Because what is happening here, Madam Chairperson, in clause 10.1, it is an offense. That is what 10.1 is saying. But if you go to 10.3b, we are being told that for law enforcement officers, it will be an exception. For them, it's not an offense. And this is the problem we have with this law, Madam Chairperson. Everything else is okay. But it seems we have a problem with when it comes to law enforcement officers. I'm standing here wondering, in whose interest are we exempting the law enforcement officers? We've already said clause 10 is dealing with prohibiting of recording of private conversations without prior notice. That's the objective of clause 10. Now, why is it that under clause 10(3)(b) we want to exempt law enforcement officers? And that is why, for me, the proposal is that if recording a private conversation is an offense, Madam Chairperson, it should remain an offense. Why are we exempting law enforcement officers? In my view, Madam Chairperson, we already have other safeguards to deal with certain circumstances. Why are we allowing law enforcement officers, Madam Chairperson, to get away with recording private conversations? So the amendment which I'm proposing this afternoon, in performing my responsibilities as a lawmaker, Madam Chairperson, is that in clause 10(1), we insert the word intentionally immediately after the word device, and then under clause 10(3)(b), Madam Chairperson, we delete the exception which is allowing law enforcement officers to get away with that offense. Madam Chairperson, this is the amendment.
Thank you. The Honorable Minister of Home Affairs and Internal Security.
Thank you very much, Madam Speaker. Madam Speaker, there is no dispute that the honourable member is performing his duties as a lawmaker. However, we object to the amendment which is proposing, taking into account that under subsection 3A, we have already taken into account the issue he has raised.
Thank you. Mr. Mpundu.
Iris.
Just summarize your submission.
Madam Speaker, Madam Chair, we are back on the same subject. Drafting laws is a responsibility of the Ministry of Justice. The proposing ministry, the Minister or Ministry of Home Affairs and the Ministry of Technology. Again, you can see, Chairperson, that we are dealing with one and the same issue here, which we've just been discussing in the previous law that was being proposed by, the Ministry of Technology. Here, it is very simple, Chair, Madam Chairperson. What Honorable Kangombe is speaking to is the fact that you now want to allow deliberate prying into our privacy. On one hand, you want to create a law that criminalizes or stops individuals from recording a conversation, but you now want to allow law enforcement agencies without any safeguard to record our private conversation. In the other discussion, Madam Chairperson, there was even a safeguard that law enforcement agencies would be required to get some authority. Here, you want to leave it very plain and open that law enforcement agencies can.
Can you continue, Honorable Member?
The means of misinformation is.
You please continue. We are behind time.
Thank you, Chair. The means of misinformation needs to be told what to do at this point. So, Chairperson, again, we are not asking for anything sinister here or special. The Minister of Home Affairs, honestly speaking, we have the right as citizens to enjoy our privacy. Whereas on one hand, you are stopping, deliberate recording of private conversations. Why would you want law enforcement agencies to be going into a private conversation without any safeguard? So what Honorable Kangombe is basically asking, delete this, provision, because it will empower unnecessary prying into our private conversation. In the other law, under the Ministry of Technology, why do you now agencies to be, conversation? I think that we are not special here, Chairperson. All we are saying is that there is already a law sitting in the other, law, which is the cyber security, law. Why are you introducing the same provision in the next law, except here you want to remove the safeguard. For whose interest are you saving this? This is the same law, Chair. This is the same law. Why are you introducing this law without providing a safeguard? If it was convenient that in the other law, which we have just concluded, you saw the need to provide a safeguard, why do you want to remove that safeguard under this law? That is, I think that, Chair, there's nothing special about what he's asking. He's asking, can we harmonize these two pieces of legislation? That is why, Chair, as I conclude, these two pieces of legislation that are being separated today were sitting as one law. Okay? There would have not been any duplicity if we had left it as it was sitting one law that took care of this matter we are talking about, which is recording conversations.
Mr. Mpundu, we are talking about the submission, the amendment.
Yes,
Let's not
Chair.
talk about what we would have wished it to
Yes,
be.
yes, Chair. We are speaking to the same thing.
Yes.
What we are doing right now, we are making two pieces of legislations that used to sit as one law. The cyber crimes law, it was one law, as it is one law as we are speaking right now. What the two ministers have done is simply to separate them. But look at the duplicity and look at the confusion they are creating.
You can wind up, you can wind up, because you are talking about one and the same thing.
Chair, here our mandate is to enact laws. We don't want tomorrow for people to be asking, what were you thinking? Remember, once beaten, twice shy. This parliament has enacted laws before where people sit afterwards and say, but what did we do? The grade 12 as an example. So we don't want to leave it to chance here that we allow a law to pass through without interrogating and asking the necessary question, which is why, performing our duty here, through Kangombe here, we are proposing that we delete this law, through Mr. Kangombe. We are, sorry,
Okay,
Chair.
I think, Honorable Member, we can't allow you to proceed any further.
Yeah, why?
Yeah,
Why? What
because you
about
are
that?
repeating the same things. Just
But I want to
wind
make
up.
an emphasis. This is
No,
my time.
just wind up. The Honorable
I am
Member
winding,
has
Chair,
taken
by
note of
suggesting
what
that.
you are saying. Just wind up. Continue, wind up.
Chair, we are not asking for too much. All we are asking is, this is the same law that is existing under another provision that we have just concluded. In there, you put a safeguard. You cannot remove the safeguard on another law. Because what you now do is you now ask law enforcement agencies to start abusing our right to privacy when you remove this safeguard. That is what we're basically asking here.
The Honorable Minister of Home Affairs and Internal Security.
Thank you, Madam Speaker. Madam Speaker, I listened very attentively to the submissions by the Honourable Member of Parliament for Nkana. And he has admitted that there are already safeguards that have been put place in the law, Cyber Security Services Bill. And the Cyber Security Services Bill, which was presented by the Minister of Science and Technology, covers law enforcement agencies. They are bound by that particular law. For them to initiate a process under the Cyber Crimes Bill, they have to follow what is obtaining under the Cyber Securities Bill. There is no way, Madam Speaker, that you can isolate one law and implement one. As a law enforcement agency, when you are enforcing laws, you have to look at all the laws that affect that particular issue you are determining. You can't start splitting hairs. If a law enforcement agency, as we debated earlier, wants to listen to your conversation, they will follow the procedures that we have already passed. We cannot now sneak in amendments to defeat the earlier law which we have passed. So, as far as we are concerned, Madam Speaker, we are on all fours and we are on fair tema on this matter. We cannot start amending laws with a view to defeat the other law which we have passed. The intention is already covered under 3A. So it's not an issue. And there is no way a law enforcement agency will deliberately want to abrogate the law. If he does that, there are sanctions. He's on his own, as we always say. So the amendment does not hold water. We have already addressed those issues under the Cyber Securities Bill.
Thank you. Mr. Mwambazi.
Thank you, Madam Chairperson, and thank you, Minister of Home Affairs. Laws cannot be read in isolation, like the State Council has said. And if you look at Section 10, if we insert the word intention, proves the mens rea. We don't need to embed that in here, but that is a court's role. For us, I think this is adequate, as it said, and they should be read in tandem for us to understand them and adequately pacify them, because we cannot just put an intent in subsection 10, but we need to leave that to be determined by the court. So I feel this section 10 is sufficient, Madam Chairperson. I thank you.
Thank you. The last member, Mr. Kangombe. Be brief.
Mwambazi, Deputy Minister Kwat. Madam Chairperson, I want to read the provision in the bill, because the Minister has just explained that it will not be a problem, but I'll explain where the problem is. 10(3) reads, despite subsection 1, and I hope that everyone is reading, despite subsection 1, it shall not be an offense. It shall not be an offense to record a private conversation where a law enforcement officer reasonably suspects. According to this law, the law enforcement officer can get away with this particular issue. That is what this provision is saying, and this is dangerous. This law is dangerous, Madam Chairperson. It is saying everyone else, if you record someone, it's an offense. But for law enforcement officers, Madam Chairperson, it shall not be an offense, provided the law enforcement officer reasonably suspects. That is where the danger is, Madam Chairperson. Because people haven't read this document. You haven't read this document. Honorable Katako, you haven't read. That's why you're arguing.
Mr. Kangombe,
Yes.
Please address me.
I'm the one moving there. I'm saying, can we make it an offense if someone intentionally records? We end there. Anyone who intentionally records, it's an offense, Madam Chairperson. We end there. But if we are going to go to 10(3) and start exempting one officer, we start exempting officers of the state, that you are exempted, Madam Chairperson, they will not be reading the securities bill. They will be using this bill. They will be using this law, Madam Chairperson, and they will be saying, go to I don't want to be part of this decision today, because this decision is allowing law enforcement officers, Madam Chairperson, to record people, and it will not be an offense, and it is in black and white, Madam Chairperson. In short, Madam Chairperson, for the benefit of my colleagues that are gathered here this afternoon, the law needs to be amended. After this stage, this will become law. We can't create a law that exempts law enforcement officers, Madam Chairperson. If you record someone, Madam Chairperson, it should be an offense. And this is my submission, and I hope those that haven't understood the provision can take time to read We are exempting law enforcement officers, Madam Chairperson. I beg to submit.
The Honorable Minister of Home Affairs and Internal Security.
Thank you, Madam Speaker. Madam Speaker, we have been on this debate from yesterday, talking about the issues of reasonableness. I'm aware that the Honorable Minister of Information did debate this matter, the issue of reasonableness. And I'm aware, Madam Speaker, that the courts have interpreted reasonableness on a number of occasions. For the court to determine a certain matter, they also delve into issues of reasonableness and have pronounced themselves on this issue. Issues which we are looking at now is if an officer feels that there is a threat to life, then he invokes this. If you look at 10.3, it talks about threat to life, threat to property, immediate danger. And the issue, honorable colleagues, has been interpreted so many times. Even yourselves, you would, when you are arguing with your colleague, you say, I think you are being unreasonable. You can prove. And if you think that the officer, the law enforcement officer, has usurped his powers, you can sue. There are provisions in the law. Even under the Police Act, under the Penal Code, there are issues of reasonableness. If a police officer reasonably suspects that you are committing an offense, they will arrest you. And that's what the law says. We cannot start defining issues here that are different from the existing laws. Reasonableness can be defined and can be established. And we have already said, Madam Speaker, there are procedures pertaining to actions of law enforcement officers. If they act outside the law, they will be held accountable. Madam Chairperson, we don't support the amendment.
Thank you so much. I think we've discussed enough. It's time to make a decision whether to take this amendment by Honorable Kangombe or not. I put the question. The question is that clause 10, as amended, stands part of the bill. As many as are of that opinion say aye. Aye. Of the contrary say no. No. I think the noes have it. The question is negative. Amendment falls away. Clause 11, prohibition of illegal devices and software. Any debate and objection? Clause 11 is agreed to. Clause 12, prohibition of computer-related misinterpretation and computer fraud. Any debate and objection? Clause 12 is agreed to. Clause 13, prohibition of cyber extortion. Any debate and objection? Clause 13 is agreed to. Clause 14, prohibition of identity-related crimes. Any debate and objection? Clause 14 is agreed to. Clause 15, prohibition of pornography. Any debate and objection? The question is that Clause 15 stands part of the bill. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that Clause 15 be amended with the words as circulated.
The question is that Clause 15 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 15 as amended. Any further debate? I put the question. The question is that Clause 15 as amended stands part of the bill. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 15, as amended, is ordered to stand part of the bill. Clause 16, prohibition of revenge pornography. Any debate and objection? The question is that Clause 16 stands part of the bill. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that Clause 16 be amended with words as circulated.
The question is that Clause 16 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 16 as amended. Any further debate? I put the question. The question is that Clause 16 as amended stands part of the bill. As many as are of that opinion say aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 16 as amended is ordered to stand part of the bill. Clause 17, prohibition of child pornography. Any debate and objection? The question is that Clause 17 stands part of the bill. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that Clause 17 be amended with the words as circulated.
The question is that Clause 17 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 17 as amended. Any further debate? I put the question. The question is that Clause 17 as amended stands part of the bill. As many as are of that opinion say aye. Aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 17 as amended is ordered to stand part of the bill. Clause 18, prohibition of child solicitation. Any debate and objection? Clause 18 is agreed to. Clause 19, prohibition of child grooming. Any debate and objection? Clause 19 is agreed to. Clause 20, prohibition of online human trafficking. Any debate and objection? Clause 20 is agreed to. Clause 21, transmission of unsolicited deceptive electronic communication. Any debate and objection? The question is that Clause 21 stands part of the bill. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that Clause 21 be amended with words as circulated.
The question is that Clause 21 be amended with words as circulated. Any debate and objection? Amendment is agreed to. Clause 21 as amended. Any further debate? Mr. Mpundu.
Madam Speaker, Madam Chair, I beg to move that Clause 21 be amended with the words circulated.
I don't think we are there. We are not yet there. We are still dealing with the amendment by the Minister.
Chair, I can comment there.
No, you can comment on your amendment. I put the question. The question is that Clause 21 as amended stands part of the bill. As many as are of that opinion say aye. Aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 21 as amended is ordered to stand part of the bill. Clause 21 as amended. Any further debate? Mr. Mpundu, you can come in now.
Madam Chair, I beg to move that Clause 21 be amended with the words as circulated.
The question is that Clause 21 be further amended with the words as circulated. Any debate and objection? Amendment is agreed to. Clause 21 as further amended. Any further debate? Mr. Mpundu? Mr. Mpundu?
Chair, thank you so much. I have asked that we amend Clause 21, and this is the reason. Chair, if you look at the original bill, in 21B, which I'm proposing to amend, it originally suggested that the initial transmission of multiple electronic messages. Okay, because 21A number 1 says a person shall not intentionally and without lawful authority in B initiate the transmission of multiple electronic messages from or through a computer system. Now, listening to the minister, he is now making a qualification that we then include the word harmful. But this is what the minister, chairperson is proposing, which is why I want to move this amendment. Chair, the minister is qualifying this original statement by suggesting that the person commits a crime if he initiates the transmission of multiple electronic messages from or through a computer or computer system for purposes of causing harm or disruption of a computer or computer system. You can understand the vagueness in this statement, Chair.
Continue. We don't want to lose your submission.
The minister is proposing the multiple messages that one is going to initiate or transmit. He is qualifying that that message will cause harm. The question would be, if we left this at that level, it is harming to who? If you left this, can you sit down? You don't know what you're doing there.
Mr. Mpundu, just wind up your debate. We want to make progress.
What I have proposed, Madam Chair, is that we delete this entire statement, because as it has been presented, it is very vague. When you propose that somebody who initiates a multiple messages, I'll give you an example. If I am communicating to my people in the communities, in the advent of social media, we have several WhatsApp groups in our communities. I initiate one single conversation that I then send to multiple, groups. Now, the minister is saying this, for it to qualify to be a crime, it must be harmful. The question is, it is harmful to who? Because if you leave it that vague, it is too vague and it is subject to being abused. Now, I don't think, because the last sentence says...
You can try to summarize and wind up.
Chair, we have enough time today.
No, because you keep on repeating. You are repeating. You are like you're almost finishing.
You need to understand this, Chair, because even you to confuse you.
Summarize, we make progress.
Chair, the danger is that if we don't interrogate this, even you'll be confused. So we need to open it up to understand
Mpundu, I think you can take your seat. You don't need to involve me in your debate.
No, I'm just saying.
No,
Chair,
don't involve me in your debate.
because you will also be participating in these votes.
No, I'm the chair. I'm not part and parcel of your debates. I'm just guiding the debates. That's all. So don't include me in your debate. You are just supposed to support the reason why you made that amendment. That is all. Straightforward. Within even 2, 3, 4 minutes, support your amendment. We don't have to debate, explain. You just support your amendment. That's all. I'm sure the point was, you've gotten the point, Honorable Minister.
Madam Chairperson, I would like to remind the House that when I came to the House to present the bill, I did mention that we did make consultations with the stakeholders. Major stakeholders who are involved in cyberspace were consulted. And this amendment I've made arose out of the various consultations we made. And according to them, the proposal I have made covers their concerns. You have to look at the term purpose. If the purpose is to cause harm and injury to the public, it becomes an offense. Because anybody, it doesn't become an offense. And that is what we are saying to the public. And us, as a responsible government, we agreed to the proposals that were made by members of the public and other stakeholders. In that premise, Madam Chairperson, we don't support the amendment that is being moved by the Honourable Member of Parliament from Kana, who is a blogger.
Mr. Kangombe, be brief, precise to the point.
Madam Chairperson, maybe what the minister should have done is to use this opportunity to respond to the issue in the context of what is the clause intending to achieve. Madam Chairperson, the clause has to be very clear. Individual, is it harm to society? Is it harm to the computer? And for me, who has read the provision, there's clearly no clarity on who will be affected by the multiple forwarded. It's deleted since it's ambiguous. And that is why clarity, Madam Chairperson, we are making a law. We need to leave knowing that we are clear what provision we are approving. It is not a matter of saying that's why we are doing this and that. We need to get clarity, Madam Chairperson. You've allowed us to stand here today. We changed the standing order specifically to deal with this business. Clarity is required, Madam Chairperson, and I don't think there's any harm in the issues that Honorable Mpundu has raised to be clarified on this floor. This harm is going to affect who? And that is why it's important that there's clarity. Is it on the computer system? Is it on the individual? So that we are clear. So before the amendment is considered, I thank you.
Okay. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I don't know whether our colleagues would like us to start framing charges here. The clause is very clear that anyone who initiates the transmission of multiple electronic messages from or through a computer or a computer system for purposes of causing harm or disrupting the computer or computer system, there must be an individual who initiates this process. It's very clear. I don't see the ambiguity here. I don't see the ambiguity. That's why we have made an amendment. We are responding to the concerns of the stakeholders. And the stakeholders themselves made proposals on how they wanted clarity on this matter. Madam Speaker, Madam Chairperson, you may recall that a number of stakeholders came to us and stated that some of the criminal offenses are not very clear. And we went back, as usual, as the listening government, and clarified the offenses. And we have clarified. There is no ambiguity here, unless one wants to create ambiguity on this particular definition. Thank you, Madam Speaker. Chairperson.
Thank you. We have to decide. I put the question. The question is that clause 21, as further amended, stands part of the bill. As many as are of that opinion say aye. Of the contrary say no. I think the noes have it. The question is negative. Amendment falls away. Clause 22, prohibition of use of computer or computer system for offences. Any debate and objection? Clause 22 is agreed to. Clause 23, prohibition of unlawful disclosure of details of investigation. Any debate and objection? The question is that clause 23 stands part of the bill. Mr. Chanda?
Madam Chairperson, I beg to move that clause 23 be amended with the words as circulated.
The question is that clause 23 be amended with words as circulated. Any debate, any objection? Amendment is agreed to. Clause 23 as amended. Any further debate? Do you want to come in?
Mr. Chanda.
He hasn't indicated. Mr. Chanda?
Thank you so much, Madam Chairperson. Forgive us that some of us are doing these things for the first time. Madam Chairperson, the proposed amendment to clause 23 one of the cyberspace, especially in cases where we have accidents and emergencies, and the publication, the taking and publication of images of accident victims, etc. Madam Chairperson, this proposed amendment is then controversial, but is proposed to cure what is becoming a very serious trend in the life of our nation insofar as it relates to the cyberspace. I think in my very few words, what the people of Kanchibi are proposing is very clear, Madam Chairperson, that we are talking about protected image, and this of course is speaking made means including photographic, film, video or digital representation of a person at the scene of an accident or an emergency who as a result of that accident or emergency is dying or dead, seriously injured or in a state of nervous shock. Madam Chairperson, I beg to move.
The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, whereas I do appreciate the issue that is being raised by the Honourable Member of Parliament for Kanchibia, I would not want to have it part of the law currently. Otherwise, we are going to arrest almost, hundreds of people, taking into account what is happening. Some of them, they are doing it innocently so that they are letting members of the security service to come to the aid of those who have been injured. I know it's a moral issue, it is a concern, but I don't think it will be in our interest currently to criminalize that. All what we have to do is to inform members of the public that they must be responsible. Otherwise, we'll create a problem. I appreciate the issue you have raised, but I don't think at the moment we should make it part of our laws. Thank you, Madam Chairperson.
Mr. Mwambazi.
Thank you, Madam Chairperson, and thank you, Honorable Chanda, for that submission. And Honorable Minister, Madam Chairperson, I do hear the submission of the Minister, but I think what also I would like to find out, because first and foremost, I think ignorance is not a defense, but how then, Minister, are you going to ensure that these people, because this vice has been going on for too long, and the base for sure is a moral issue. But how then do we deter, or how do we regulate to ensure that people do not perpetuate this vice? I do understand your submission that we shouldn't, we can take everybody to jail, but then how do we regulate to ensure that people can know that this is a moral issue and then we mitigate it? I thank you, Madam Chairperson.
The Honorable Minister of Home Affairs and Internal Security.
Thank you, Madam Chairperson. Sorry. Madam Chairperson, this is now the responsibility of ourselves as government to ensure that there's awareness on the part of members of the public that they should not be doing such activities or taking pictures of a deceased person or an injured person and start circulating them. As I indicated, some of the intentions are noble. They are trying to alert the security wings and others that there is an accident which needs attention. We will take into account your submissions and ensure that in future, if there will be need, we shall take appropriate action.
Mr. Chinkuri.
Thank you so much, Madam Chairperson, and thank you so much to the Honorable Member, Sunday Chanda. I'm just trying to find out, looking at what he has submitted. Indeed, I would want to agree with what the Minister said. However, there are certain people that get affected, by seeing certain, pictures, and I find this picture is just sent on someone just sees it, faints. So in such instances, how would the government, look at those in event someone, is affected by what has been, passed by someone who should not have passed it? I submit.
Thank you.
The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, as I indicated earlier, it's now incumbent upon us as government to educate members of the public to desist from taking such videos or pictures of persons who are injured or who are dead. And usually what happens, if you are disseminating to members of the public, if you are a broadcaster, you warn members of the public that the pictures they are going to see are sensitive. That's what we should be doing. We have taken note. There's no doubt about the issue that is being raised by the Honourable Member of Parliament. We'll take into account those issues and maybe not put regulations to ensure that such things don't happen. But for the time being, I would urge my colleague not to insist that it should be part of the law.
Mr. Chanda.
Thank you so much, Madam Chairperson. Madam Chairperson, I want to thank the Honourable Minister for the response as provided, and I definitely do get the rationale by government that maybe that's in terms of legislation, it's a piece of, it's an issue whose time in terms of legislation has not yet come. But I think it would be important that all of us under the ministry responsible for internal security looks at how to curb this particular trend, which is becoming a menace. The trauma it's causing for affected families, etc., issues around privacy, confidentiality. Imagine that you are seated and the first thing is that you see a close relative on your gadget in an accident. I think that can be highly traumatizing. So my appeal and the appeal of the people of Kanchiwia is that beyond this particular submission, proposed amendment, government takes research and can this be regulated, because it's a disturbing trend, Madam Chairperson.
The Honourable Minister of Home Affairs and Internal Security.
It's an assurance, Madam Chairperson.
Thank you. We can make a decision on the submission by Honourable Chanda. I put the question. The question is that clause 23 as amended stands part of the bill. As many as are of that opinion say aye. All the contrary say no. The noes have it. The question is negative. The amendment falls away. Clause prohibition of harassment, humiliation, etc. Any debate and objection, clause 24 is agreed to. Clause 25, prohibition of cyber attack. Any debate and objection, clause 25 is agreed to. Clause 26, prohibition of cyber terrorism. Any debate and objection, clause 26 is agreed to. Clause 27, offences resulting in incapacity or destruction of critical information and critical information infrastructure. Any debate and objection, clause 27 is agreed to. Clause 28, entering into agreement. Any debate and objection, clause 28 is agreed to. Clause 29, search, seizure and seizure by law enforcement officer. Any debate and objection, clause 29 is agreed to. Clause 30, restoration and forfeiture of property. Any debate, any objection? The question is that clause 30 stands part of the bill. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that clause 30 be amended with words as circulated.
The question is that clause 30 be amended with words as circulated. Any debate, any objection? Amendment is agreed to. Clause 30 as amended. Any further debate? I put the question. The question is that clause 30 as amended stands part of the bill. As many as are of that opinion say aye. Or the contrary say no. The ayes have it. The question is resolved in the affirmative. Clause 30 as amended is ordered to stand part of the bill. Clause 31, point of order.
Madam Speaker, standing order number 239. We can only conduct business if the quorum is formed. Is this House in order to continue doing business without the required number of members of Parliament in the House? I seek your serious indulgence.
I'm going to allow the clerks to confirm. We have a quorum. They're almost done. Four people. I'm told we are missing 4 people. Can we have 4 people so that we finish? We are almost there. Ring the bells. Ah. Oh. Order, we will make progress. Clause 31, assistance. Any debate, any objection? The question is that clause 31 stands part of the bill. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that clause 31 be amended with the words as circulated.
The question is that clause 31 be amended with words as circulated. Any debate? objection, amendment is agreed to. Clause 31 as amended. Any further debate? I put the question. The question is that clause 31 as amended stands part of the bill. As many as are of that opinion say aye. Please support your minister. Of the contrary say no. I think the ayes have it. The question is resolved in the affirmative. Clause 31 as amended is ordered to stand part of the bill. Clause 32, expedited preservation order. Any debate and objection? Clause 32 is agreed to. Clause 33, disclosure of traffic data. Any debate and objection? Clause 33 is agreed to. Clause 34, collection of traffic data. Any debate and objection? Clause 34 is agreed to. Clause 35, extradition. Any debate and objection? Clause 35 is agreed to. General amendment on pages 14 to 20. Any debate and objection? The question is that the bill be amended on page 14 to 20. The Honorable Minister of Home Affairs and Internal Security.
Madam Chairperson, I beg to move that the bill be amended on page 14 to 20 with words as circulated.
The question is that the bill be amended on pages 14 to 20 with words as circulated. Any debate and objection? Amendment is agreed to. The bill as amended on pages 14 to 20, any further debate? I put the question. The question is that the bill as amended on pages 14 to 20 stands part of the bill. As many as are of that opinion say aye. Aye. Of the contrary say no. The ayes have it. The question is resolved in the affirmative. The bill as amended on pages 14 to 20 is ordered to stand part of the bill. Long title, any debate and objection? Long title is agreed to. The bill will be reported to the House as having passed through the committee with amendments. Done. Thank you. Madam, I have to report to the House that the Committee of the whole House has gone through the Cyber Security Bill, National Assembly Bill number 29 of 2024 with amendments.
Day for consideration of the report.
Now, Madam Speaker.
Consideration of the report to be taken now. The Honorable Minister of Technology and Science.
Madam Speaker, I beg to move that the report be considered. Now.
The report be adopted. Report of the committee be adopted. As no notice has been received of any further amendment, is it your will that the report of the committee be adopted? Any objection? I see none. Report adopted. Day for third reading.
Now, Madam Speaker.
Third reading of the bill to be taken now.
Madam Speaker, I beg to move that the bill be read the third time.
It's like pushing a tractor which can't start. The question is that the bill be now read the third time. Any debate? Any objection? The question is agreed to. Let the bill be read the third time.
The Cyber Security Bill, National Assembly Bill number 29 of 2024.
Next order.
Madam, I have to report to the House that the Committee of the whole House has gone through the Cyber Crimes Bill, National Assembly Bill number 30 of 2024 with amendments.
Thank you. Day for consideration of the report.
Now, Madam Speaker.
Consideration of the report to be taken now. The Honorable Minister of Home Affairs and Internal Security.
Madam Speaker, I beg to move that the report of the committee be adopted.
No notice has been received of any amendment. Is it your will that the report of the committee be adopted? Any objection? I see none. Report adopted. Day for third reading.
Now, Madam Speaker.
Third reading of the bill to be taken now. The Honorable Minister of Home Affairs and Internal Security.
Madam Speaker, I beg to move that the third reading of the bill be made now.
The question is that the bill be now read the third time. Any debate? Any objection? The question is agreed to. Let the bill be read the third time.
The Cyber Crimes Bill, National Assembly Bill number 30 of 2024.
Thank you. Next order.
The Geological and Minerals Development Bill, National Assembly Bill number 33 of 2024. Third reading.
The Honorable Acting Minister of Mines and Minerals Development.
Madam Speaker, I beg to move that the bill be read the third time. Thank you.
The question is that the bill be now read the third time. Any debate? Any objection? The question is agreed to. Let the bill be read the third time.
The Geological and Minerals Development Bill, National Assembly Bill number 33 of 2024.
I'm just saying, the acting leader of government business, adjournment.
Madam Speaker, I beg to move that the House do now adjourn.
The question is that the House do now adjourn. Any debate? Any objection? The question is agreed to. The House? Is now adjourned. Cindy.
We leave a recap of what has been considered on the floor of the House when business resumed at 14:30, 09 hours earlier in the day, forgetting that standing order 27 and 123 was suspended yesterday. So business started at 09 hours earlier in the day. Joe, let's quickly look at the three announcements that were made by Madam Speaker earlier in the day.
Yes, indeed, Person. So Madam Speaker did make three announcements. In the first announcement, she did recognize the presence in the public gallery of pupils and teachers from Triple Alliance Digital Academy Pre and Primary School in Lusaka District, as well as pupils and teachers from Thornhill Boarding School in Lusaka District. And Madam Speaker welcomed the visitors to the National Assembly of Zambia.
The other announcement, Madam Speaker, did inform the House that Parliament Radio will be migrating from the Astra 4A satellite under Vision Consult GmbH to the Cosmos satellite. The migration process will begin on Tuesday, 1st April 2025.
During the migration process, Madam Speaker stated that the Parliamentary radio remote sites across the country will be off air. However, she said that the Lusaka frequency, 92.5 FM, will still be on air. In addition, Chirundu, Mazabuga, Monze, parts of Choma and Kawe will also be able to access Parliamentary radio on 92.5 FM.
The Right Honourable Madam Speaker further informed the House that transmission at the Parliament radio remote sites across the country is expected to be restored by Friday, 30th May 2025. The inconvenience the process will cause to the Parliament radio listeners, especially in rural, or should I say remote sites, is deeply regretted. So those were the announcements that were rendered on the floor of the House. There was a ruling that was rendered on the floor of the House, and this ruling was on a point of order raised on Tuesday, 18th March 2025 by Honorable Jijin Kombo MP, Minister of Local Government and Rural Development, against Mr. F.R. Kapyanga, Member of Parliament from Pika constituency, and Mr. L. Simumba, Member of Parliament for Nakonde constituency, for voting in a matter that concerned them.
Yes, indeed. So, Madam Speaker did remind the House that on Tuesday, 18th March 2025, when the House was considering the motion of thanks to the President's address on the progress made in the application of national values and principles, and Mr. Y. Mtayachalo, Member of Parliament for Chairman North constituency, was debating, Honorable Jijin Nkombo MP, Minister of Local Government and Rural Development, raised a point of order which was premised on Standing Order 221, which provides for the naming of a member. And Madam Speaker stated that in raising a point of order, Honorable Nkombo MP stated that the rules of natural justice dictate that one cannot be a judge in his own case. Further stated that as the House was voting on a person to suspend or not to suspend Mr. Kapyanga, Member of Parliament from Pika constituency, and Mr. L. Simumba, Member of Parliament for Nakonde constituency, both voted despite involved in the matter on the floor of the House.
And after citing relevant authority, Madam Speaker proceeded to say that in argument, his point of order, Honorable Nkombo, stated that the two MPs who were a subject of the question to be resolved should not have participated in voting for their own fate, as this was contrary to the principles of natural justice, which dictate that a person shall not be a judge and a jury in his own cause. And Honorable Nkombo, he said that Standing Order 1, that's the Right Honorable Madam Speaker, said that Standing Order 161 and 25 of the National Assembly of Zambia Standing Orders 2024 on electronic voting provides that unless the Speaker or Chairperson of committees otherwise direct voting on a division in the House shall be conducted electronically.
She did add that unless the Speaker or Chairperson of committee otherwise directs voting on a division in the House shall be conducted electronically, or when the Speaker or the Chairperson of committee, as the case may be, directs that an electronic vote be taken, the division bell shall be run for 5 minutes.
And in conclusion, in this ruling, Madam Speaker said that therefore follows that Mr. F. Kapyanga and Mr. L. Simumba, MP, were eligible to vote and did not breach any standing orders on the aspect of the principle of natural justice, that a person shall not be a judge and a jury in his own cause. She considered the view that this does not arise, and she therefore told Mr. F. Kapyanga MP and Mr. L. Simumba MP were present and eligible to vote and were therefore not out of order. So that's a ruling that was rendered on the floor of the House by the Right Honorable Madam Speaker.
After that ruling process, we had 3 ministerial statements. The first one was rendered by the Minister of Foreign Affairs and International Cooperation on the official working visit to Japan on 3rd to 7th February 2025.
The other ministerial statement that was rendered on the floor of the House was done by the Minister of Home Affairs and Integrity, Honorable Jacob Muimbo. And this one was on the issuance of national registration cards through mobile registration.
The Honorable Minister for Foreign Affairs and International Cooperation, Honorable Mlambo Haimbe, also rendered another ministerial statement on the 38th ordinary session of the Assembly of Heads of State and Government of the African Union held in Addis Ababa, Ethiopia from 15th to 16th February 2025.
After the consideration of those 3 ministerial statements, the House proceeded to consider questions. There were questions for oral answer, Understanding Order 82. These are urgent nature. The first one came from Mr. Simpundu Chembe, Member of Parliament, directing his question to the Minister of Energy. The member wanted to find out why health facilities in Chembe Parliamentary constituency are subjected to load shedding by ZESCO Limited, despite the presidential directive not to load shed health facilities. And the response by the Minister of Energy did say that in line with the presidential directive that health facilities being exempted from load shedding, Chembe Health Facility is given 12 hours of power supply due to lack of a dedicated line. And the big part of the question, what urgent measures are being taken to ensure that the health facility are not load-shedded in order to prevent loss of life. The minister did say that government has directed public institutions to go to rooftop solars, and government through the Rural Electrification Authority has already provided and installed solar system in various health facilities, and they are ready to provide technical assistance to these health facilities as and when they are requested.
Yes, indeed, President. So question 276 was expected to come from Mr. Yotam Charo, Chairman of the Member of Parliament. He wanted to find out from the Minister of Education why local applicants in each district were not prioritized during the 2025 teacher recruitment exercise, why the exercise was not district, and whether local applicants in each district who were left out will be prioritized during the teacher replacement exercise. So, Madam Speaker, I did guide that the question should lapse because it was not in a proper format.
All right, so those were the 2 questions for oral answer that were supposed to be tackled on the floor of the House today, but unfortunately only one was able to be considered on the floor of the House. And there were 3 bills that were considered on the floor of the House. 2 bills came at committee stage, and 1 came at third reading stage. And the Cyber Security Bill, National Assembly Bill number 29 of 2024, and the Crimes Bill, National Assembly Bill number 30 of 2024. Both of these bills came at committee stage, passed committee stage with amendment. The report was considered, support stage was considered and adopted, and it has passed the 3rd reading stage.
And also the Geological and Minerals Development Bill, National Assembly Bill number 33 of 2024, passed all the stages.
So basically, that has been today's business that has been considered on the floor of the House. On behalf of my colleague, Joe Katama, not forgetting the 2 sign language interpreters, thus Jason Manda and Chola Kaoma. Joe, the House has adjourned Senate, looking forward to the committee. We know that the Local Government Accounts Committee will be sitting starting Monday the 31st of will be considering the CDF through the local authorities.
Yes, indeed, President. So actually, I was just asking myself to say, I thought we are done. Probably I just thought of, okay, we still have local government accounts committee, so we'll still be here on Parliament TV, bring up to date regarding the Committee on Local Government Accounts.
So I'd like to urge you to join us on Monday as we continue broadcasting live the Local Government Accounts Committee. We know that they will be considering the CDF 2024 report. So best thing that you can do is to stick around and enjoy and see how these issues, or should I say, these public funds have been dispersed across the 116 local authorities dotted across the country. On behalf of the entire production crew, we're saying thank you.